Hi, I'm Vivian Dempsey, and this is The Writing Edge. I'm about to discuss Performance Test B, Draper, from the summer 2013 bar exam. This is about the admissibility of an expert's testimony. The expert is one in domestic violence cases. The defendant is objecting to the testimony based on three grounds. One, that there's no proof that the defendant is an abuser. Two, that there's no evidence that his wife suffers from battered women's syndrome. And number three, this was the first time there ever was violence in a marriage. Those are not the three issues, though. There were three statutes and three cases, and they pretty much line up with each other. One case, one statute. Evidence Code 352, which is more prejudicial than probative, is basically what the Gould case talks about. The Gould case says, since this is the first incidence of violence, how can we say that there is a history of abuse? And if there's no history of abuse, then an expert's testimony about abuse is not relevant and in fact would be more prejudicial than probative. So that's based solely on the fact that this is the first incidence of violence. The Bowen case contradicts this and says it doesn't matter if there's no previous violence because, number one, the cycle of violence begins long before physical violence erupts. There's emotional abuse first, and so the fact that there hasn't been any history of physical violence doesn't mean that an abusive relationship does not exist in this case. And the second thing that Bowen says is that we know of no rule that abuse must be established before the credibility of a witness can be assessed. And here, the wife recanted her testimony and said, no, never mind, it was an accident, my husband didn't really hit me. And because the credibility of the wife is an essential part of the case, although she has withdrawn her complaint, and it's the prosecution bringing the case of its own merit, the DA bringing the case of its own merits. Her proof of the statement that she made to 911 saying my husband hit me is still going to be an important part of the prosecution's case. So credibility of the wife is still very much at issue. So that goes also to first incident because the Bowen case says 80% of the time when there's physical abuse and it's the first time that there's been physical violence, the wife recants. So the Bowen cases focus on the cycle of violence and how necessary it is to have an expert witness testify about that because it's not in the common experience of lay people to know about the cycle of violence. So it makes expert testimony crucial. The third case is the Slater case. And the Slater case lines up with relevance, that is logical relevance, probativeness. And the Slater case says there are really two things that have to be proved to allow an expert testimony to come in. First, it has to be, there has to be an existence of a preliminary fact laid as a foundation to make the expert testimony relevant. And second, the expert testimony has to be probative to a contested fact. I find the two prongs of the Slater test to be the structure for your entire answer. So you could go two ways. You could do the three cases as the structure for your answer, three cases lining up with the three statutes, or you could do the Slater case as what I call a mothership and use the two prongs from it. That's your first slide. Take a look at that. The Slater case breaks into foundation must be laid of the preliminary fact of abuse, and the Gould and the Bowen case go to that. They, of course, are concerned with more prejudicial than probative. The second prong is the probativeness being the logical relevance, and there, in order to make the expert testimony relevant, it has to be related to or must address a fact that's at issue. And there we go back now to the three things that the defendant is claiming. He's not an abuser, his wife's not abused, and it's the first incident. What you do, and what I did on my issue sheet, is I went through every single word that our expert said, Professor Simoni, and I linked it to one of the three things that, that the defendant is claiming. Okay. So Simoni said that it's very common for abusers to minimize and demean and criticize their spouse, take away their confidence. Well, we have evidence that that happened in our situation, both from the wife and also from the wife's brother. So lining up what Simoni said with one of the contested things, and that fact, of course, would go to D is an abuser. Okay? Emotional abuse is also abuse. Right? So you go through, literally, there were, I don't know, 6 or 7 pages of Simoni's testimony, and take it statement by statement. Where there's a statement about which we have no evidence, such as one thing Simoni said is that many abusive husbands are drinkers or they abuse drugs. Well, we don't have any evidence about that. So that evidence could be stricken. That statement by Simoni could be stricken because it isn't related to anything we have on our facts. So the main work in this performance test is lining up every word of Simoni's transcript with one of the 3 objections that D made. And that is the solution to this performance test.